Right, so your shareholder agreements really regulates the rights. Well, let's take it a step back. There's three purposes for a shareholders agreement. The first is that it records and regulates the finances and the management of the company. The second thing it does is it outlines the rights, responsibilities, and duties of your shareholders. And then the third thing it does is it regulates the relationship between the shareholders to the company and the relationship between individual shareholders. Look, there's plenty of shareholders agreements on the internet that are available. They do become problematic though if those shareholders agreements need to be customized to a certain set of circumstances. The ones on the internet generally don't make sufficient provision for if there's a dispute between shareholders. So it really is encouraged and advised that independent legal advice is taken into account when those agreements are drafted. Look, at the end of the day, it entirely depends on the attorney you go to. The profession is based on an hourly rate, which is regulated by that attorney's experience and their knowledge of the industry. But generally, ballpark figure, you're probably looking at between 4,000 to 6,000 Rand plus VAT. The biggest risk is what happens if there's a fallout between shareholders. My saying is you can't unscramble an egg, so prevention is better than cure. You need to make provision for instances, specifically if there's only two shareholders in a company that own 50% of that company. What happens if they can't reach an agreement? That's the most important role, well, one of the most important aspects of a shareholders agreement, is that you can be very specific in how that dispute is resolved, and more importantly, who resolves the dispute. The second important aspect of the shareholders agreement is to make sure what happens if one of the shareholders dies. What happens if they go insolvent? What happens if one shareholder wants to sell their shares? Provision needs to be made to protect the other shareholder. And that's done by means of what we call a right of preemption, where the remaining shareholder is given the right to purchase the shares from the shareholder that wants to opt out.